Welcome to this latest interview in the series The Law's Two Bodies. The title and some of the inspiration for the project comes from Sir John Baker's book of the same name. Central to the book is the argument that the common law is almost universally regarded as a system of case law, increasingly supplemented by legislation. But this is only partly true. There is an extensive body of lawyers' law which has a real existence outside the formal sources, but is seldom acknowledged or discussed either by legal theorists or by legal historians. So our project asks the question, what is law? But pursues an answer in a fashion different from typical jurisprudential studies. It examines what legal practitioners do, how they regard law, to what extent they think about law in the abstract. The approach is ethnographic rather than philosophical or sociological. The aim is to build up a corpus of interviews with a variety of legal practitioners concentrating on the issues outlined above. The interviews involve a set of questions posed to all interviewees, and then further questions arising from the initial answers or which are appropriate to each interviewee. At present, the purpose is to stimulate thought rather than to produce any publication. The aim is to create a set of interesting case studies rather than a carefully representative sample of practitioners. I'm John Hudson, and today I have with me Richard Nicholl. Richard currently serves as a third sixth pupil at 4 Pump Court, the commercial chambers in Temple, London. Richard completed his pupillage at One Essex Court, where he developed a broad commercial practice. He studied law at Emmanuel College, Cambridge, graduating in 2015, having specialised in public law. Subsequently, Richard earned an M.Litt with distinction in legal and constitutional studies from St Andrews in 2018, with a particular focus on legal history, notably on the now highly topical issue of jury trial and its critics. He's a member of the Inner Temple and was a Princess Royal Scholar during his bar professional training course. He's also worked for the litigation funder Burford Capital and as a paralegal at the Office for Students, the university's regulator in England. So, Richard, what portion of your working time now is spent engaging with matters that you describe as ones of law?
Well, as a commercial barrister, I would say that I would hazard about 60 to 70% of my time is fundamentally legal based, and that will consist of research of legal topics, research of a particular problem, drafting legal documents, particularly particulars of claim and defences and that sort of thing, and of course actually being in court arguing the case. This will vary somewhat depending on where in the profession you are, what kind of work you're doing, what kind of area of practice you are. But as part of that, quite a lot of that work is going to be what we would think of as questions of fact, but interpreting those facts through a legal lens. So actually questions of what you would call pure law are actually quite a lot less common than questions that lawyers would immediately think of as mixtures of fact and law. The rest of the work I do, though, is much more in the realm of soft skills, soft abilities. So there's a huge amount of diplomacy and tactical nous that you have to develop in order to have the career. And although these are often quite strongly inflected by law, they're not themselves clearly legal in content. A good example is that a huge amount of your time as a barrister is spent negotiating with your client, negotiating with the other side on issues of settlement, of disputes that don't make it to court. And these are obviously important for the clients, important for their way of business, but they have critical legal procedural consequences under the civil procedure rules in terms of what happens to your cost budget, what happens to how things are treated in court, and all of that is set down by rules that are in legislation or forms of legislation but do not actually impinge on truly legal questions. So there's a great deal of diversity in how we conduct ourselves.
Let's move on to the things that are truly legal, or legal properly so-called, or whatever you want to call them, and then move on to the things that you are suggesting might be excluded from that. So where do you get your knowledge of procedural and substantive law from? In broad Is it books? Is it other people? Is it internet? What is it? How do you do it?
Well, it's apt in the question that you separate procedural and substantive law. The primary source that one has as a barrister for one's knowledge of substantive law begins at one's law degree. It is what you pick up when you're studying the compulsory 7 courses plus the other courses that are relevant. But ultimately, mine is getting a bit long in the tooth. Now, I graduated in 2015, which is 8 years ago now. A horrifying thought, really. And so consequently, huge amounts of it are going to be, if not completely out of date, but will at least need to be updated substantially. If I were a criminal lawyer, for example, there was a very important case that happened during my law degree called Crown against Nango, which was very important to the joint enterprise rule in criminal law. That has since been updated by a more recent case.
Can you explain to me what the joint enterprise rule is?
It's in potted terms, it is to do with when a defendant can be held guilty for the crimes that were actively committed by other people, and the circumstances in which that's possible. But so as I say, that's getting a bit long in the tooth. But what it's really useful for is getting the contours of what kind of legal arguments you will have to actually face in practice into your head. Good example, for instance, is that I spend a lot of time in my current in my role working with extensions of time or exclusion clauses, all of which are really live debates in contract law, and you learn about them on your contract law course. But the contours of them are just different because they've had 10 more years of development since I studied them. So that means that in substantive terms, your real first source as a barrister is the enormous compendious texts, textbooks, practitioners' manuals. The book I cite most often is Chittium Contracts, which I read virtually every day for some kind of source on something else, because although you will have the background to know what it's talking about, to know the areas you need to know, you will not know it in enough detail from your academic learning, or at least in your undergraduate degree. But even they constantly run out of road because the exact dispute that you're dealing with will not have come up before, because if it had come up before, it would not be a dispute and you would not be needed. So you have to work by analogy. The procedural stuff, on the other hand, is much more closely taught on what used to be called the Bar Professional Training course when I did it. Before that it was called the Bar Vocational course. Now it's called the Bar Training course. They can't decide on a name for it. And that is the extra degree you do after you finish your qualifying law degree. And that teaches you about civil procedure rules, teaches you about ethical requirements and that sort of thing, all of which are more or less legislative in origin, and you have to know them as well, and you have to know them almost with a little more felicity and ease than you do the substantive questions. You have time for the substantive questions, you often do not have time for the procedural questions, so you kind of need to know them pretty rapidly.
That's very interesting. Do you think this, you learn the substantive law in your degree and you learn the procedural law in your professional qualification, does that suggest some sort of mental hierarchy between the two, at least amongst legal academics and possibly amongst practitioners as well? Yes.
This may vary by jurisdiction, though. I think in England it is quite... I say England, I probably mean England and Scotland, but I don't know enough about the Scots legal system to really speak with authority on that. But I certainly think that in England, my experience is that academics are insufficiently interested in procedural law. But that is beginning to change, kind of, I think, as more feedback comes through from the profession and how it actually works in practice. But I think the existence of a sense of internal hierarchy is definitely the case, even though procedural questions are probably more common, although they're much less complex usually. There's usually a clear answer to them that you can derive from the civil procedure rules or the criminal procedure rules if you're a criminal practitioner. But they are no less important because they fundamentally alter the nature of the dispute that is in front of the court, or in front of the client, or in front of the two parties who are trying to come to some kind of resolution.
So that is the areas that one might call formal law.
Yes.
What about this suggestion that Baker and others put across? How far is the shared body of legal knowledge amongst practitioners, which isn't cases, which isn't statutes, which in some sense you can't simply look up and can be described as law's second body or as soft law, or you may have other words for it. Is that important, and how do you learn that?
It's absolutely critical, but some are easier to pin down than others. There's probably two paths I can go on this. The first is the clearer one, which is to say ethics and regulation, which, as I said initially, at least have a vague root in positive law in some sense. There is the Bar Handbook, for example, which is a text upon which you have to rely if you're dealing with ethical problems, but they are always extremely vague, and actually in reality all of it functions at bottom. These are fundamental issues of law. Ultimately they can be enforced by legal mechanisms, actions in professional negligence, for example, or the quasi-public enforcement you get from a BSB complaint or something like that, but really what they are norms of practice. The good example I can give on this front is that one thing lawyers are taught very insistently in their vocational studies are that you must not plead fraud in a case unless you have very good reason for doing it. And the reason this exists is to prevent court from collapsing into recrimination and difficulty, and also because fraud is very difficult to prove. But what that actually means is very, very hard to pin down, because the standards of what constitute good enough evidence to plead fraud are something that vary between practitioners. I mean, one practitioner who is an experienced civil fraud practitioner might say, I think I can probably make this stick. I think I have the evidence at least to put this before the judge, even if he or she disagrees with me. But a less experienced practitioner like me would almost certainly say, I'm not touching this with a barge pole, and send it straight back to solicitors and say, I can't plead fraud on these facts. And that is something that is shared primarily through experience, primarily through communication informally, through learning at the foot of another barrister, either your supervisor or your leader, and it develops over time. It's so necessarily fact-based that it would be almost impossible to provide for it ahead of time through legislation, through anything like that.
Supervisor is someone that you're working with out of court and lead your lead in court, or what's the difference?
No, supervisor is what used to be called pupil master.
Right.
It's the person who looks after you during pupillage or person or persons. Your leader is the person who is the top named barrister on a case, who will typically have other barristers working underneath them for support, who we call juniors. Usually the leader is a silk, a KC, but not always. And it is usually in those kind of relationships where the norms of how this stuff is done are transmitted and understood and alter over time.
So that very much fits with the notion that this really is an oral culture, this aspect. Yes,
I think oral, and I think also in some senses unspoken, in that one picks up these things almost by this actually is the fraud point, for example, and the ethical point is really a sub-point of a wider issue, which is that the ways in which you practice, the ways in which you plead cases are, in theory, set down in legislation, but really aren't. And the ways you pick up in pupillage in the early years of practice about how not to conduct yourself, how to conduct yourself in court, how to be aggressive in the right ways, conciliatory in the others. This emerges not necessarily positively taught. It emerges from you occasionally getting an explicit word of advice from someone who's more senior to you, but more often it emerges from you over time figuring out what works, and you will typically do that by listening intently in court when your leader is in court, paying attention if you know what they're trying to say, paying attention and noticing what they don't say and where they don't lay emphasis, how they respond to judges, how they respond to the apparent mood of judges, for example, the apparent feeling of whether a judge is interested in one point and not interested in another. And over that time you get an almost intuitive sense of how something should be structured that would be impossible to write down or prescribe, but is no less, I would say it's no less binding. It's almost like the observation we make about morality, in that you would not be able to write down a full moral code for how a person should behave, but that doesn't mean that the judgments they make are less binding, that people are less bound by their moral judgments. It's ultimately the same kind of approach, and it emerges in the same kind of way as moral principles emerge in daily life.
I like this breaking down of the normal binary between written and oral, that it's now triplical. It's a trifold distinction between written, oral, and unspoken and unwritten.
Observed, almost.
Observed,
way of putting it, yes.
I mean, you were including within this area elements of what some people call courtcraft. Is there a limit to how far this can be considered a body of law? Is there an outer boundary, or is it all such a continuous spectrum that it becomes impossible to draw any lines?
Well, it's difficult to think of it as a body of law in that respect, in that you wouldn't be able to. It would be very difficult to make an objectively justifiable case on any one of these points by addressing yourself to what is felt as an external imposition upon you. That is more what we think of as in terms of a body of law, in that it is a thing, an authoritative set of things that control or ought to control how you conduct yourself as a practitioner. But it isn't. It's not quite like that. It's more. It is to law what culture is, I think, in all other areas of life, in that it sets the constraints in some respects. It doesn't impose itself objectively and suddenly, but you simply learn that there are things that you do not do or that you must do. And they're not, their bounds are as wide as the atmosphere is bound, and that they infect everything you do, not just in your professional life, but the moment you become a lawyer, they ultimately affect how you conduct yourself in your day-to-day life as well, because you're living in an identity that is part of a culture that is not yours entirely to control, but that emerges over the crucible of being in legal practice over time. And it's almost not quite right to imagine that it has boundaries in the same way that civil procedure rules have boundaries, in that there are clear things to which this applies and which it does not apply. It's too wide-ranging for that, and it doesn't, as I said, it doesn't quite operate as a body of law qua law, but it's inextricable from law. Where you have law, where you have lawyers, you will have this development of a legal culture of, as you say, courtcraft. Because otherwise the system must produce this as a necessary byproduct of having people who work in it, because lawyers and judges are not, they're not, I wouldn't even go as far as say they're not robots. What they are not is deterministic, predictable instruments. They are human beings, and human beings can only function in a culture, and the emergence of that culture happens naturally.
We won't go into this, but one of the things that is interesting about that is whether this form of legal culture is peculiar to common law, or whether it will exist in all legal cultures. But how far are other legal systems of interest to you, and are they of practical interest to you?
Yes, I mean, you encounter other legal systems all the time, really, but in different sort of ways. The obvious one as an English lawyer, obviously, is Scotland and the Commonwealth, and to a slightly lesser extent, non-Commonwealth common law jurisdictions like the United States, Ireland, Israel, Hong Kong, Singapore. Such cases are not, strictly speaking, authoritative in England. You can't cite them before a court and say, therefore, your lordship, you must follow this. But in practice, they are often the only time that a particular point has ever been discussed or aired or dealt with. The trouble is, though, that as a source of law, it's extremely hard to know where to look, because you're not intuited in that system, you don't necessarily understand the waypoints where you would begin to search this sort of thing. And usually within this jurisdiction, the only way you can get to these cases is through commentaries that refer to it in some other way. And I love looking at this stuff, but it can bog you down. And there was a case about a decade ago called Arnold in Britain, which reaffirmed that the Supreme Court really doesn't like you oversighting authority. The Supreme Court, speaking for all courts in England, doesn't like you oversighting authority on issues of contractual interpretation, because the court takes the view that every contract is fundamentally individual, and there is only so much you can draw from other cases where a similar contract has been considered, so please don't do it very much if you possibly can avoid it. And that applies with even more strength to cases that aren't even in the jurisdiction. And it's distracting to judges. They need to be attentive to what's in front of them a lot of the time. And non-English authority, I mean, if it's not really necessary or really useful in some way, it's usually best to avoid it. For non-common law, though, dealing with civil codes and things like that, it is not of much use to barristers but it may be useful to solicitors because it will offer examples of how similar situations, certainly in the form of drafting contracts or of drafting other instruments of some kind, have been dealt with in other jurisdictions. And although the underlying core of it is different, the underlying legal structure that enables it is different, that doesn't mean that that still means that the same incentives are being obeyed in some sense. But it would still be more marginal, I think, than looking at the common law would be. The other one that you're often dealing with in practice is a lot of what you might call, I would say, specialised systems, which are, strictly speaking, contained within the English legal system, but are isolated from it quite critically. I mean, the big one is arbitration, which I do a huge amount of these days because it's in construction and in shipping. Most cases are arbitration cases because the parties tend to prefer that it's dealt with by an arbitrator. Now, arbitration formally does not set precedent. That is one of its rules, in that no arbitrator is bound by another arbitrator. But it isn't as simple as that, because arbitrators are usually retired judges or barristers with big commercial practices or big shipping practices. A lot of shipping barristers, for example, have a sideline as an arbitrator. Certainly once they get to about 25 years coal and they fancy making a lot of money while not doing a great deal. So increasingly in my experience, although I'm still very junior, so take this with a reasonable pinch of salt, I think that arbitrators seem to increasingly expect some kind of citation from another arbitrator, as if they are judges looking for guidance from another previous court. But it's primarily so that they feel confident enough to make the ruling that they really want to make in the first place, and sideline, they don't want to have an appeal under Section 69 of the Arbitration Act if it's available, which it usually isn't. So it develops elaborate complexities around that leave it in tension with the overwhelming sphere of English law, almost in spite of its core principle of not being engaged in that area. And it's a field that's very difficult to analyse in that respect because so much of it is confidential. Almost all arbitration clauses contain a confidentiality clause. If you look for arbitration appeals on Westlaw, what you will find is in the matter of arbitration appeal number 1 of 2022, because they won't name any of the parties or any of the matters involved, because they're bound by a confidentiality agreement. And so it becomes almost this sort of dark matter of law-like practice, which is very difficult to analyse, certainly from an academic point of view, although I'm sure there are some creative scholars in this room who might want to prove that wrong.
I think it's interesting from that point of view is that the major international arbitration lawyers actually suggest a fairly small body of people,
yes.
And it may not be written down, but they talk to each other about it. How far are you interested in law in the abstract? And again, does that affect your practice?
I mean, it is not, law in the abstract is not hugely important in my day-to-day work. I mean, clients do not want your essay. They want analogy. They want to have advice that draws from cases that are similar that they can look up and that they can cite, and more importantly, that the solicitors can write about in letters to the other side saying, go away, we've got this case, you need to give us a settlement right now or we'll take you to the High Court and beat you up. But, you know, in various different ways of putting that. Except insofar as occasionally a more abstract question is useful because there's a point of principle that's fundamentally unsettled in law. And judges will want guidance of some kind on a point of principle. For example, I'm working on a matter at the moment where the position in how you would deal with a particular type of clause in a contract differs apparently quite dramatically between England and Scotland. But some English courts have displayed an interest in the Scottish approach, and there's just not much appellate authority on it in England. So the judge in this matter is going to want some kind of principled guidance on how this ought to function, but will mostly be looking for the analogy from previous cases. I mean, for myself, I find it really interesting. I mean, you can tell this from the way I'm waving my hands around when I talk about it. It's partly from sort of political theory standpoint, because that's some of my background, some of my interest. But I have a really strong interest in institutional analysis, of how law adjudication systems for this kind of thing alter outcomes through procedure, through manipulation of that procedure, And I find that stuff fascinating because it's a bit of a blind spot, I think, to people who are not already immersed in and very skilled at the manipulation of those procedures. If I had a strong background in this kind of work, I'd like to do more theoretical stuff on this kind of thing in the West, but I'm time poor at the moment. That's the nature of being a junior barrister, I'm afraid.
When you were talking about referenced previous cases in arbitration law, I was reminded of how people overestimate how old the doctrine of precedent is in English law. And what you're talking about sounds like late medieval law, where you cite cases and they carry weight,
yes,
but it isn't a doctrine of precedent as it develops thereafter. How far are you still interested in
yes,
legal history? And does it come into your work?
Well, I mean, it would be remiss of me not to mention the wonderful education I had under a certain Professor John Hudson, a certain Caroline Humphreys, some time ago. Not all that many years ago. I mean, I'm very interested in it. It's of acute importance, but in practice, having a historical outlook is important, but it's not evenly important. You can get through your professional career very, very well without having a strong legal history background or a strong legal history understanding. I mean, legal history methods are very, very useful, and a sense of history is very useful, I think. I'm working on something at the moment which is to do with what we call extension of time clauses in construction contracts. So you're building, I don't know, a bridge or a railway network or something, and something goes wrong, and it's delayed, and imagine that. But what typically happens is that there will be a provision in the contract that gives the contractor more time to finish. Now, the analysis of this, which comes up all the time in construction law, is that if you know the history of why these clauses exist in the first place, the reason they were introduced in the first place is because the common law had developed an independent system dealing with it called the prevention principle, which is about how an employer of a contractor cannot take advantage of doing something that caused the contractor to breach the contract. And therefore all the time provisions that are set up in the contract get suspended if the employer is found to have done something like that. And the introduction of these extension of time clauses was not meant to protect the contractor, it was meant to protect the employer, so that they could preserve the bargain that they had previously struck with the contractor, and therefore preserve their understanding of the economic position that led into whatever contract it was that they were setting up. And that's very useful knowledge, because you understand why these clauses exist, what the point of them is, and what the aggregate understanding of the legal profession that went into drafting standard form contracts is meant to be about. And that means that you don't end up going down blind alleys, you don't waste your client's time and money, which is critical to getting on in this career. Don't waste time. I mean, it's more observed in the breach than but certainly in my case. But it also allows you to explain much more effectively to the court why whatever interpretation you're arguing for makes more sense, fits more easily into a wider picture of law in this area. And it's very helpful because it lends a sense of coherence to your submissions. It lends a sense that you are not... If your argument is accepted, then the picture is right, that things are regular and straight and in the structure that they ought to be in, and if you don't do that, the historical sense is very good at giving that impression that what you're saying is not just right, but it has to be this way, because otherwise something will be out of whack with the system as widely understood.
The last question seems slightly detached in some ways, but actually sums up quite a lot of things we've been talking about. You talked about courtcraft and being able to read courts, and you also early on said that a lot of your non-legal time is dealing with clients and dealing with solicitors. So how far do matters of emotion come into your work, and how far is it the role of law to exclude emotion from disputes?
It's an important question to put it in that bifurcated sense, actually, because emotion really drives disputes enormously. I mean, one thing you learn, I think you actually learn this most efficiently at the very junior end of the bar, is that people do things for strange reasons. They pursue disputes for strange reasons, for reasons that they don't entirely themselves understand. Two examples of this. I mean, I have a colleague who did a case fairly recently where I think there was a building dispute of some kind, and no, it was a dispute with the bank. Excuse me, it was a dispute with the bank, and it was just an ordinary customer, and they were litigating in person. That is, someone who's not represented by a lawyer, and they'd been through this dispute for ages and ages and ages, and the bank had stood its ground and all this kind of thing, and they were going to fight it. But on the day of the trial, the bank had really gradually, over the previous couple of weeks, come to the conclusion that they had screwed up, actually. And they instructed my colleague to go up to the claimant and apologise on behalf of the bank. And as soon as she did that, she dropped the case. Didn't even bother going after them for the money, because that was what she wanted. And I don't think even she knew that she wanted that to start with. But more recently, I mean, I dealt with something a couple of months ago. There was someone who was extremely aggrieved over a bill, the utility bill, but I can't say any more than that for obvious reasons. But it was quite small, it was fundamentally quite small, and he was entirely in the wrong. And I was acting for the other side, and he had been led into completely fruitless litigation because he was so wildly aggrieved over what he felt had been like some kind of snub or injustice, that he started deciding that almost what a lawyer would understand as just points of not even error on behalf of the company he was dealing with, but just not being entirely polite. That kind of developed into this widely, deeply felt sense of being aggrieved and having been suffered at the hands of contract law. And people do these in strange ways, and you get all the fun of the fair at the county court. I mean, it's wonderful. But I mean, courts are meant to be formal places, but it's important not to confuse that formality with a lack of emotion, exclusion of emotion, because not only does emotion drive dispute, and judges are extremely alert to it, and they have a sense for how they should talk to, especially a litigant person who's not represented, to make them settle themselves and feel like they've not been horribly aggrieved. And in some sense, some people, there's nothing you can do, but there's some people who can be diverted from fruitless appeals, from ringing people up constantly every day to scream at them, and demand things from them. But also that in practice, emotions are really important for how those of us who are properly legally trained actually communicate with each other. There are little tells judges have, not necessarily the most reliable in terms of outcome. You can't really predict the outcome from a judge, but what you can do is identify where the judge wants you to go. It's very easy, once you're alert to it, to know that a judge is bored, fundamentally bored by the point you're making, and that happens all the time. And the usual response to that is to get through the point as quickly as possible and move on to something you find more interesting, more persuasive, because it gives you signals about how your point is going down with the judge, whether you should focus on one bit of it, whether you should move on to something else, and that makes you a more compelling and more useful advocate. But it requires you to be very, very controlled, because you can't at any point lose your rag, and that is very difficult. When you're dealing with very unreasonable people, it's very difficult to not lose your temper, and it's unprofessional, obviously, to lose your temperature, to lose your temper, and people will notice, and it will get back to chambers, and it will get back to solicitors if you lose your patience too much in court. But you also have to remember, and this takes me back to what I was saying earlier on about regulation and ethics, in that you are not yourself in court. You can't be. That's not what you're for. You are someone else. You are both your client's representative and you are an officer of the court. Formally, you're an officer of the court. You exist to assist your client, to represent your client, and also to contribute to the working of justice. And if you allow your own emotions to enter into the court, not only are you doing something unprofessional, you're actually doing something that's formally incorrect. You are introducing a person into the court who formally shouldn't be there, and that person is you. You don't belong there. You inhabit your own body, you conduct yourself in the way that you should as a professional, but you, the person who has their own issues or their own troubles, or even more importantly, their own feelings about a matter, shouldn't be there. That should be left at home. And that's difficult. Not allowing the personal you to take over when that whole system is requiring you, not demanding. The system cannot function if you are yourself. You must be something else. And that's not easy. I mean, I have a colleague in Chambers who was really upset recently because he won a case, I think it was to do with it was a building case of some kind, and it was just an ordinary person. And his side, he was acting for a building company, and the other side was, he was entirely in the right. His client was entirely in the right, and the other side shouldn't have pursued the litigation really. But he was devastated by it because that meant by winning that the other side was ruined, financially ruined. They suffered quite severe, they lost quite a lot of money. And he felt awful about it, really, really awful about it. And mastering that and learning to see yourself as part of the system, not as you, is really, really difficult. It doesn't come easy to people, and it's not something you do early, but it's something you have to point yourself towards throughout your career. And it's necessary, that kind of role play. And that kind of control is necessary. And I think it is fruitless to try and get to imagine that law should or can exclude emotion, but it has to control it and channel it. Otherwise, everything collapses into dust because you just can't run the system that way. I hope that makes sense.
Thank you. That's been absolutely riveting. Thank you, Richard.